National Report Court is back in session. Today's case, a Catholic couple claims that Massachusetts banned them from participating in the state foster care system due to their religious beliefs.
Mike and Catherine Berg saying it's due to their adherence to Catholic teachings on gender, sexuality, and marriage specifically. So taking up the case for the purposes of this segment is Thomas Jipping. He's a senior fellow with the Heritage Foundation. And Andrew Lieb, he's an attorney and legal political analyst. Thank you both. For the purposes of the segment, so Thomas can represent the couple suing, and Andrew can represent the Massachusetts Department of Children and Families. So again, for the couple here, Thomas, I'll go to you. The lawsuit states this, quote, "As faithful Catholics, the Bergs believe that all children should be loved and supported, and they would never reject a child placed in their home. They also believe that children should not undergo procedures that attempt to change their God-given sex, and they uphold Catholic beliefs about marriage and sexuality." So again, Thomas, does this family have a case?
Yes, they do, both under the First Amendment and under federal statutes. By denying or rejecting the Berks solely because of their personal views on sexuality, their religious views, the Department of Children and Families in Massachusetts violated three different First Amendment principles that the Supreme Court has recognized, as well as it flies in the face of DCF's own policies and regulations. The Supreme Court has said that the government cannot compel someone to present and advance a certain message as a condition in the Supreme Court case of doing business. That was the 303 creative case. And yet here, DCF is doing exactly that. There's only one message, one view of sexuality that the Department of Children and Families will tolerate, and that's the one that violates the Berks' religious views. Supposedly, the DCF, their own regulations and policies prohibit religious discrimination in choosing foster parents. Supposedly, they prioritize seeking religious families to be part of this program, and supposedly they prioritize applicants who are willing to take children with special needs. The Berks meet all these criteria, and yet there was one overwhelming consideration, and it's the only consideration, and that is that they have to agree to promote a particular view of sexuality. The Berks will not do to foster children what DCF is doing to them, and that's discriminate on the basis of religious views.
All right, we got to keep it moving along. Got to get the second opinion. Andrew, here, the lawsuit lists the reason for denying the Berks foster application is that they would not be affirming to the child who is identified as LGBTQIA. Is this legally allowed in Massachusetts? What's the defense's argument?
Emma, I don't even know what we were just hearing a second ago, because first of all, there's only two different constitutional principles, not even three that are pled. And if you would have Thomas's viewpoint, you would consider that raising foster children to be a business. He's citing to 303 creative, which is about business expression in trying to make wedding websites. How does that raising children? This is about our children and our families. And clearly in Massachusetts, there's a regulation in the Code of Regulations for Massachusetts that says, and I don't know what the Berks are saying in their lawsuit, you could plead anything, but what it says right over here is that you have to be supporting and respecting a children's sexual orientation or gender identity. And the Berks have said they wouldn't support. It's not saying that they have to give gender affirming care. I don't know where that came from. What it's saying is you have to be supporting and affirming of the children. Don't you want children that to know you're going to come out of a system and you're going to be loved and you're going to be told that who you are matters? This is about raising our children, and that's all we have, an equal protection for our children. They're the people that need to be able to be protected. Equal protection clause justifies what they're doing in Massachusetts. This is a compelling state interest.
And again, I'll go back to Thomas on this. If you'd like to respond, you can. And it's hard in this case because you can argue from an ideology standpoint, but in this terms, it's about the law. And if we can, get back to the legal point of this, Thomas, and how this can be argued, how this can be won or lost by the family.
Well, the Supreme Court has held in the Fulton versus City of Philadelphia case, for example, that in that case, the city could not exclude the Catholic Church or Catholic agencies from the foster care system because of their views on sexuality. I think the parallel there is obvious. The Burkes have said that this isn't going to make any difference as to how they love and welcome children. They're not going to keep any children out of their home based on their sexuality. They're not going to kick them out of their home based on their sexuality. The government is wanting them to promote and affirm. Well, if you look at the process by which the foster care system works, a single social worker can make a subjective judgment on 17 different qualities that an applicant has, including this respecting and supporting. It means whatever that social worker says it means. Well, that's okay up until the point where it requires an otherwise qualified applicant to violate their religious view.
All right, Andrew, we'll give you the floor for the final response.
I think Thomas is creating words here. He just said promote and affirm. The statute says support and respect. Promote and affirm are not support and respect. If we're going to put on any words we want, we could just fight on facts that don't exist. He's citing to Fulton. Yeah, Fulton's a 2021 decision from the Supreme Court, but that's about Catholic services contracting with Philadelphia to be able to work and get money from Philadelphia to help distribute foster children. We are here now talking about our children. Do we want to go like this and go, we're just going to go give out children to anyone and do whatever? Or do we want to have systems and rules to protect the most vulnerable among us, the children, and give them equal protection to develop who they want to be under law? No one is saying that they have to give gender-affirming care. That's not what's going on here. The key is, will you support and respect children? And someone with a license, a social worker, to understand that, assess that these people wouldn't. And that is the final word.
All right, Thomas Jipping, Andrew Lieb, if you can stick around for the purposes of this segment, as you've been arguing, we also have someone to play judge and jury within this segment, Gerard Fillity, Senior Counsel with the Lawfare Project. We appreciate that. So, Gerard, obviously, differing viewpoints here, differing legal arguments here. Well, how did you come down?
Well, first of all, I love being both judge and jury. It makes my life a lot easier. Here, there are two things that come to mind. First, the religion issue is a big one. You're essentially saying you're not going to let Catholics adopt because of their beliefs, but those beliefs are shared by other major religions as well. Are we not going to allow Muslims to adopt, Jews to adopt? This becomes an issue of we're prohibiting anyone who has religious viewpoints that differ from state guidelines from adopting, and that's a problem. That is where you get into First Amendment issues. But the other issue here is policy. What it sounds like is that this violates the policy of the agencies involved in the adoption process. So we have to see how that plays out, because if they're violating their own policies, that's a bigger and stronger argument that these rules are impermissible. So here I would find for the couple.
All right. Gentlemen, appreciate you coming on. Again, this was a really interesting case, and we, again, appreciate you taking it up for the purposes of this segment only. Thomas, Andrew, and Gerard. With that, National Report Court is adjourned. Take care, gentlemen. Thank you very much.
Thank you.
All right, and we've got enough